Breaking news here. Judge Tanya Chutkan of the D.C. court has granted Donald Trump's request for a stay of all proceedings in his D.C. criminal case, writing that Trump's appeal on presidential immunity grounds has forced her hand. All pending deadlines and court dates in that case will be stayed but not vacated. This is about the appeal to the Supreme Court that Donald Trump has presidential immunity. Donald Trump didn't appeal to the Supreme Court, but Jack Smith did. The Supreme Court said, yes, it will considering it. It has asked Donald Trump's team to come up with a response to Jack Smith by next Wednesday, I believe, December 20th. And now Judge Chutkan is saying until the Supreme Court rules on this, she's going to put everything on hold. She's not vacating it. It's not getting thrown out, but she's going to put everything on hold.
As you mentioned, very familiar with the January 6th case in general. A lot of the rioters who stormed the Capitol, who got some of the harshest sentences, got them from her in her courtroom. And she made a pretty crucial ruling against Donald Trump himself back when the January 6th committee in Congress wanted to get the Trump White House records and documents. Donald Trump objected to that and said no, because of executive privilege, they should not be able to get their hands on them. It was her ruling that actually ruled against Donald Trump and allowed the January 6th committee to have that information. And that was a really important ruling, not just because it basically allowed the committee to build their entire case, but because of what she said in that ruling. Really became famous, the words that she put forward. And she said here, quote, "Presidents are not kings, and the plaintiff is not president. Executive privilege," she went on, "exists for the benefit of the republic, not any individual, and accordingly can be overcome by an appropriate showing of public need." Now, those words themselves made headlines. They were cited many times in Congress.
In the case, the fundamental underlying issue. This is what Nixon versus Fitzgerald was all about in 1982 in the civil context, to find absolute immunity on separation of powers grounds and other grounds, because the president must be able to act freely. In this case, at all times, President Trump acted under Article 2, Section 3 of the Constitution, which provides simply that he must faithfully execute the laws. Based on the information he had, he believed that he was acting to investigate what he believed to be election fraud. He was acting consistent with his duty, his oath under Article 2, Section 1, Clause 8, to execute his office faithfully, and so on. That's what he believed. But their point is, a president must be able to act freely and not worry about criminal liability over official acts in office. And the Nixon and the Fitzgerald court even said the outer perimeters of the office. This is the heart of the office.
Mark Meadows will have his charges tried in Fulton County Court. For months, he'd been trying to get his case moved to federal court on the grounds that he was a federal employee when he committed the alleged crimes in 2020. The court decided that statute doesn't apply to former federal officers. He can appeal his case again, but this time to the U.S. Supreme Court.